All right, so today we're going to be talking about the many ways in which the Constitution protects those accused of a crime. But before we get into that, let's do a little hypothetical. So pretend that you are a judge, and this case comes to your courtroom. So a male assistant principal at a school gets a tip that a female student gave her friend prescription strength Tylenol. Based on this tip, the assistant principal brings the student to the office. While the assistant principal looks on, a female secretary and female school nurse ask the student to strip down to her underwear and they pat her down. No Tylenol is found. The student and her mother sue the school, claiming that the school violated her Fourth and then 14th Amendment rights. You might be wondering, wait a minute, why 14th Amendment? Is this a sex discrimination case? Well, no, right? Remember, this is a due process clause issue, right? So the due process clause of the 14th Amendment makes it so that state and local officials, like school assistant principals, have to follow the Bill of Rights too. Remember that idea of selective incorporation. But getting back to this case, right? What do you think about the student and her mother? Suppose that you, being the judge, this case ends up in your courtroom. Which side are you going to rule for and why? Did the school violate the student's rights, or is the school acting appropriately here? All right. So there are four key amendments in the Bill of Rights that protect people who've been accused of a crime. Now, this to me really indicates how important what we call the rights of the accused were to the framers of the Constitution. So, four amendments there's the fourth, fifth, sixth, and eighth. And we're going to go through each one of these in detail and talk about how it protects your rights if you're accused of a crime. Now, most of these amendments have been applied to the states through the Due Process Clause of the 14th Amendment. All right. So let's start with the Fourth Amendment. How does that protect you? Well, as we talked about when we looked at the Bill of Rights, the Fourth Amendment protects you against searches and seizures, which is a fancy word for arrests, conducted without a warrant. The warrant must be issued upon what's called probable cause, and that is a reasonable suspicion that a crime has been committed. So as an example, if you've ever watched a crime show, you've probably seen the police get probable cause, right? So suppose that the crime lab finds your DNA on a murder victim's body. The police can bring that evidence to a judge and obtain a warrant to arrest you on suspicion of the murder, right? So the way probable cause works, right, the police have to have some sort of evidence that reasonable suspicion will say that a crime's been committed. They bring that to a judge, and then the judge has to sign the warrant basically and say, yes, you can go arrest this person in the case of an arrest warrant, or yes, you can go search this person's property, their belongings, etc., etc. All right, but there are actually quite a few exceptions to this warrant requirement. And the first is the evidence is in plain view. So for example, suppose a police officer knocks on your door for whatever reason. They don't think you've committed a crime yet, but when they knock on your door, you open the door and then the police officer sees drug paraphernalia on the table behind you. She can search your home then without a warrant, so she doesn't need to go to a judge because the evidence is in plain view. Now, another exception is if there's an immediate threat to public safety. So, for example, a police officer's walking by a house and he hears gunshots and somebody screaming inside, right? Well, we would probably assume in that situation that someone is in immediate danger. So that police officer doesn't need to go to a judge. That would take time, right? He doesn't need to get a signed warrant. He can immediately go into the house and see what's going on, right? He doesn't need a search warrant because it sounds like someone's life is in immediate danger. Now, third exception, some car searches require probable cause, but they don't require a signed warrant. And if you're wondering why this is, the logic behind it is that cars obviously can move. So if a police officer takes the time to, call up a judge and then go try and get a warrant signed, well, that car is obviously going to be driving away by the time the police officer goes to a judge, right? And the evidence that the crime has been committed is going to be long gone, right? So what might that look like? So suppose that a CHP officer pulls you over for a broken taillight. He says he smells weed. That's considered probable cause. He does not need to go to a judge and get a warrant for that. He can search your car and look for that weed, right? So this kind of varies a little bit by state. The Fourth Amendment can get kind of tricky. So your best bet is if a police officer wants to search you, don't try and fight it right then and there. Get a lawyer. All right. Now, let's continuing talking about the Fourth Amendment. Let's talk about the exclusionary rule. So, this is what happens if a police officer searches your person or your home or anything else, right? Finds evidence of a crime, but he does so, the search is illegal, right? He violates the Fourth Amendment. So, what happens when the police officer searches you, your house, et cetera, but they violate the Fourth Amendment? What happens to that evidence? So, the exclusionary rule states that illegally obtained evidence can't be used against a suspect in court. And this is actually the result of a very famous Supreme Court case called Mapp v. Ohio, which is an amazing case. This woman in the picture here is Dalry Mapp, who is the person involved. And basically, what happened was the police came to her house. They were looking for evidence that it was either a boyfriend or a husband, I can't remember, had committed a crime. He was involved in some sort of gambling ring. They knocked on her door. They showed her a piece of paper that they quickly stuffed in their pocket. They came, they searched her home, and they found pornography. And they actually tried her on obscenity charges. So believe it or not, having porn in your home used to be illegal in whatever state she lived in. And she obviously knew that her rights had been violated, but she actually thought it was her First Amendment rights. She thought she had, based on freedom of speech, the right to have porn in her own home. She brought it all the way to the Supreme Court, and it reached the Supreme Court. She was describing what happened, or her lawyer was. And the Supreme Court said, wait a minute, the police officer showed you a warrant, and then they wouldn't let you look at it. They stuffed it back in their pockets. And she's like, yeah. And the Supreme Court's like, wait a minute. So they went and they actually found out that warrant never existed. The police officer just showed like a shopping list or something to her. And there was no legitimate warrant. They searched her home without a warrant. And the Supreme Court ruled that in that case, the evidence they seized from her home couldn't be used against her because they obtained it illegally. So this is a really, really controversial rule, as you can probably imagine. So people who like this rule say that it prevents essentially police from unlawfully searching people's homes and then later using that evidence against them. But you can obviously see here, right, why critics would not like this rule. As some people say, it lets criminals off the hook on a technicality. If you've heard that expression, oh, they got off on a technicality. This might be one of those technicalities. The evidence against them has to get thrown out because a police officer made a mistake. All right. So now let's talk about the Fifth Amendment. And the Fifth Amendment, as we talked about when we looked at the Bill of Rights, is one of those sort of big jumbo amendments that has a bunch of different protections embodied with it. So let's go through those. So one of the things that it prevents is double jeopardy, which is trying somebody twice for the same crime. So if someone is acquitted of a crime, that is, they're not found guilty, that person can't be tried again for the same crime, even if new evidence is discovered. So even if, like, the police officers discover that they had, seized your computer as evidence, but they never actually looked for it or looked through it, they open it up, they find out that you searched how to murder somebody, but you were acquitted in that trial because there wasn't enough evidence against you. The police officers can't now go back to court and say, hey, we found more evidence that proves this person is guilty. No, doesn't work. There are some exceptions to this too. So if there's a mistrial or if the person has violated both state and federal law, they can be tried for the same crime in both state courts and federal courts. Another protection in the Fifth Amendment is that it prevents the government from forcing you to testify against yourself, right? So this is when you say, I plead the Fifth. That's what you're doing there. And the police do read you your rights. This is actually from another court case, Miranda v. Arizona, your Miranda rights. So the police will tell you have the right to remain silent. Anything you say can and will be used against you in a court of law. And then, as we also know, right, the Fifth Amendment also has a due process clause, kind of like the 14th Amendment. But whereas the 14th Amendment's due process clause says states can't take away your life, liberty, or property without due process of law, the Fifth Amendment says that the federal government can't take away your life, liberty, or property without due process of law. And as we remember, a due process is fair procedures and fair laws. All right, let's talk about the Sixth Amendment, which is another big one. So the Sixth Amendment has a bunch of protections. First one is it guarantees you the right to a speedy and public trial by a jury of your peers, right? As we know, secret trials, they can't be observed, obviously, by the public. It's in the name, right? So there's no way to hold the justice system accountable there. So that is why this guarantees you the right to a speedy and public trial. It also guarantees you the right to an attorney, even if you can't afford to pay for one yourself. And this right was reaffirmed in another famous Supreme Supreme Court case called Gideon v. Wainwright. So, for example, if you get accused of a crime, you can't afford to pay for a lawyer, the court will go to the public defender's office, and the public defender will defend you in a court of law. You can, by the way, waive this right if you really want to represent yourself in court, but if you're not a lawyer, I wouldn't do that. And then finally, the Sixth Amendment also gives you the right to know who is accusing you of a crime. So you can't be accused anonymously of a crime. All right. Let's talk about the Eighth Amendment now. So two big provisions in the Eighth Amendment here. The first one is that it forbids excessive fees, fines, and bail. That includes also civil forfeiture, which is when law enforcement seizes property that might have been involved in a crime. And then as we looked at, right, this is kind of the most recent selective incorporation case, which is pretty cool. And the Eighth Amendment, kind of most famously, also forbids cruel and unusual punishment. And you might be wondering, wait a minute, if the Eighth Amendment forbids cruel and unusual punishment, what does that mean for the death penalty? Well, the Supreme Court has actually ruled in several different cases that the death penalty does not count as cruel and unusual punishment. Now, if the method is really cruel or unusual, that can be prohibited, but the death penalty in and of itself does not count as cruel and unusual punishment, according to the Supreme Court. There are some exceptions here. So if the person has a mental disability and isn't able to sort of comprehend right and wrong, the Supreme Court has ruled that the death penalty can't be applied in that case, or if the person who committed the crime is under 18.